My name's Governor Watts. I'm a California lawyer, and I'm going to talk about two lawsuits that are affecting the future of the internet.
And I'm Brian, and I have some questions.
Okay, Brian. So, Brian, the first lawsuit was filed by a lawyer by the name of Pete Wilson. Have you heard of Pete Wilson?
Yes, he was the governor of California.
He was. Just like myself, Pete Wilson was the governor of California. He was back in the 1990s. And he is the lawyer for Dennis Prager. Do you know who Dennis Prager is?
Yeah, he's a conservative radio host.
Yes, and apparently runs a fake university. Very presidential of him. Prager University was an online kind of fake college thing. And he was on YouTube, and he made a bunch of YouTube videos, instructional videos, for his conservative university. And YouTube would not monetize his videos because YouTube has this policy now of not allowing controversial content to make money. So if, like, I uploaded a video where I said Australia doesn't exist, and they thought that was racist against Australians, but their algorithm did. And
Really?
So I can't make money from people who click on the ads. So Prager, who's super conservative, all of his videos are at least as bad as denying the existence of the continent of Australia. So he's not making any money. And he got the former governor of California to sue YouTube to try to say that YouTube is a public forum like a park or a town square.
Okay.
And the idea is that and they used a case called Pruneyard versus Robbins that's from the 1980s.
I'm well aware of that case.
Yeah? How do you know about Pruneyard versus Robbins, Brian?
Yeah, so I used to do petitioning, and I would petition out in front of Target, and I would get people to sign the petitions, and the Target manager would come out and they'd be like, "You need to leave." And I'd say, "No, because I'm a friend of Daniel Watts, and he says I don't have to leave because there's a case called Pruneyard versus Robbins, which states that a shopping center is a public forum and you have all your constitutional rights in front of there, even though it's technically private, it's treated as a public area."
That's right. Correct? Yeah, that's right. It applies only in California, so it's a California Supreme Court case based on these guys that were petitioning against Zionism. They hated Jewish people back in like 1979, and they went to the Pruneyard Shopping Center, which is this gigantic mega mall in Campbell, California, where they have 65 shops. They've got 16 buildings. It's got like 500,000 acres or square feet rather, not acres. That'd be like half the state of Rhode Island. But it's a giant shopping mall. And these guys were trying to get petition signatures out in this huge plaza, and the mall said, "No, you're trespassing. What are you doing? People come here to shop, and that's it." And they're like, "No, people come here to hang out." And in California, we have this constitutional right to pass laws by initiative, by getting something on the ballot. That's how we banned affirmative action in California. But you need like 500,000 signatures to get something on the ballot. And back in the 1970s, the only place where you could find 500,000 people in one place were the shopping malls in the suburbs of California.
Yeah, because there's no longer like, oh, the town square. We don't really have that anymore. And that's what we had back in the day, and that's kind of what the First Amendment is like. You're allowed to do all these things in the town square, but there's less town squares. The shopping mall today is the town square.
Yeah,
today.
The shopping malls in the 1970s.
Yes.
Were the town square.
Yeah.
So California said, the Supreme Court said, if the right to put something on the ballot with signatures has any meaning at all, if that right has any oomph to it, you have to allow people to traipse onto private property, the shopping malls are private property, and allow them to gather signatures, even though normally that would be trespassing. So certain areas of shopping malls since about 1980 have been free speech zones.
Yes, designated as free speech zones, and they are allowed to regulate the time, place, and manner of that.
That's correct. So you can't go there at midnight. If the mall closes, you can't be there. You can't bring loudspeakers there for amplified sounds because that disturbs everybody that's shopping. You can't punch people in the face to get them to sign your signature.
And they could say, like, you can't do this on New Year's Eve. You can't do it in front of this store. You can't do it here. And so how much they narrow it is a gray area, kind of. Right?
Yeah, it depends on the circumstances of the particular mall. If it's a mall where no one comes on New Year's Eve or Christmas Day, then it's fine if you go there on those days. But if it's a mall that's very high impact, where there's lots of foot traffic and it's too crowded, and people with clipboards would actually pose a fire hazard on those days, you can ban certain days from having people do free speech. So that's the 1970s and 1980s. That was the public forum there now, back then. Now, shopping malls are almost superfluous. We have the internet. You have Facebook. You have petitions on whitehouse.gov or on change.org that get hundreds of thousands of signatures without anyone ever meeting anyone face to face. So if you want somebody to sign a petition to get something on the ballot in California now, you just make a graphic of the petition and you could share it 10 million times and those people can print it out,
yeah.
sign it.
Yeah, actually they're doing something like that, like with the gas tax.
Oh, to repeal the gas? Yeah.
Carl DeMaio's doing that.
Carl DeMaio, who is a radio talk show host down in San Diego, is getting an initiative on the ballot to repeal a law, and he's a lot of it. I've seen his people out in front of Trader Joe's and Target and things, so they are trying to use that prune yard, but they're
also online. Yeah.
Also doing it online, and so now this guy Dennis Prager, filed a lawsuit saying that same logic that applies to the shopping malls of the 70s and 80s, that also applies to Twitter and Facebook and, for Prager, YouTube, because the private nature of the shopping mall was not determinative of the decision of the California Supreme Court. So the fact that YouTube is private property, its servers, that doesn't matter anymore. That's not important. That's not what's important.
Well, and the thing is Dennis Prager is having pretty much mainstream conservative views. He's not like, talking about killing all the Jews or anything like that. It's like conservative mainstream views, which are, yes, controversial, because there's obviously liberals and moderates or whatever, but these are mainstream views. These aren't completely fringe sort of stuff, right?
I don't know his views, but even if they are fringe views, you can have fringe views and still go out and protest in a public forum. So this is why this case is so interesting and also threatening to YouTube's business model, because Prager, let's just say for the sake of argument that he's not super racist, but the logic and the constitutional rights that allow you to freely speak, racists have those rights too. That's why you get all these Nazi rallies around the country now. You get these alt-right supporters, people, skinheads marching, people following them with tubas going oompa, oompa, oompa. That was a hilarious video. I don't know if you've seen that. But people mocking the Nazis are my favorite kind of videos. But these guys have free speech rights too. So if Prager is successful and he manages to convince a court to declare that YouTube is a public forum, those rights don't apply just to Prager. They apply to ISIS. They apply to ISIS supporters in America. They apply to Nazis. They apply to the alt-right. They apply to pornographers. All the same rights that I have or you have or Prager has, evil people have those rights too. And so if you expand rights for someone, you expand rights for everyone else. So Prager's problem is that he sued in federal court, and he shouldn't have done that, because federal court, this is a California state law, prune yard. So only state law can change it. The state Supreme Court can change it. It's kind of like the Lord of the Rings. The One Ring was forged in the fires of Mount Doom. It was made in Mount Doom, and only there can it be unmade. So Pruneyard versus Robbins was made in the California Supreme Court. Only there can it be unmade. So or expanded or changed or forged a different ring. But he sued in federal court. They don't have the power to destroy the One Ring. Only the California Supreme Court does. So Prager wants to change the law a little bit, because right now this has never happened. The internet being declared a public forum like this, that's never happened before.
So I think why they sued in federal is because I think they want to go all the way up to the Supreme Court. Is that correct?
I don't know, but that's an interesting idea. Maybe they do want it to go to the Supreme Court just for publicity, but there's a second lawsuit that's more likely to change the law. So this second lawsuit is filed by a guy named Jared Taylor, and Taylor is an alt-right kind of supporter guy, and he sued Twitter. He was banned from Twitter in November of 2017 for associating with violent extremists.
Associating?
Yeah. He claims he's not a violent extremist. He doesn't associate with violent extremists. But that was the reasoning Twitter gave him when Twitter canceled his Twitter account, banned him from the service. Now he's being represented. He hired a lawyer, Marco Randazza, who I went up against once in a lawsuit. He was opposing counsel, but he's a free speech lawyer out of Nevada, and they sued in San Francisco Superior Court, which is a state court, saying the same thing. Twitter is a public forum, just like the private area of a shopping mall is a public forum. And so they're trying to say that Twitter can't enforce rules like that. Twitter can't ban people who are accused of associating with violent extremists.
But then the other thing is then can Twitter ban a bot? Just like a bot that's just running and saying the same thing over and over again and tagging people and being annoying?
If Jared Taylor is correct, maybe.
Are robots people?
Are robots people? The better question is, are robots, are they expressing the views of the people that created them? If I make a robot...
Of course it is.
If I make a robot that just goes door to door and knocks on people's doors and says, vote for Daniel Watts, and then answers all the questions about people, like let's say I'm running for president, and it answers things intelligently just as if it were me. How is that different than me knocking on doors and doing the same thing?
That's true.
If you ban a robot...
Look out, New Hampshire. It's coming for you.
So, but that might be an example of a time, place, or manner restriction. Maybe Twitter says, because of the potential for just flooding everything, like a bot is a loudspeaker. A bot is the same thing as you going into a shopping mall with your megaphone, which
yes.
you're prone to do,
yeah.
and then announce things really loudly and drown out all the other speech. So maybe that would be an appropriate manner restriction. Good thinking, Brian. But so it's in California State Court, Taylor's case. So if it goes up to the California Supreme Court, the California Supreme Court could either overturn Pruneyard or expand it to the internet. And I think that it's more likely that when they get to the California Supreme Court, the Supreme Court will say, "Oh my God, what have we done? The logic is unassailable. You can't have Pruneyard and have Twitter banning Nazis. Those two concepts are irreconcilable." And so more likely than allowing Pruneyard to destroy Twitter, to completely give free rein to Nazis on the internet, I think it's more likely that the Supreme Court would overturn Pruneyard, limiting free speech in California. So that might be the unintended consequences of Jared Taylor.
So he might lose.
Yeah, he might.
And
Lose.
if he loses, all Pruneyard gets.
If he loses,
taken down.
Yeah, if he loses at the California Supreme Court, I think there's a good chance that Pruneyard's only surviving by one vote, and that was the last time Pruneyard was addressed, like squarely on the issue of whether it should be upheld, was 8 or 10 years ago, and like every justice that had voted for Pruneyard, I think except one, has been replaced on the court, and it could get overturned. And so these lawsuits against YouTube and Twitter, these conservatives think that they're going to open up these big tech companies for conservatives to express their views and use it like a public forum. But I think it's far more likely that they're going to get Pruneyard overturned.
And lose not only their own case, but lose all cases.
Yeah, they'll lose the power to go into shopping centers and collect signatures on petitions.
Well, then how will... Oh, okay, then it'll be really tough to get petitions on the ballot.
Then they'll go to Facebook. Which will ban them for being too controversial. Petitions to repeal the gas tax. But the examples, like conservatives get mad and then they go to other sites. Like there's what's that Twitter called? The Twitter knockoff that conservatives use.
What is it called? Gab.
Gab. So conservatives go to Gab. So they have an alternate public forum that they can go and talk amongst themselves if they really want to do something.
Yeah. So, okay. And then, so anyways, if you're on YouTube or you have some other public speech lawyer question, hit up Mr. Watts, because he's the guy, especially in California law and then also federal law.
Here's another
and
reason.
Japan.
Yes, Japanese law. So the reason why this is coming up this year is because last June of 2017, there was a Supreme Court case, Packingham versus North Carolina, and in that case, there was a sex offender in North Carolina who was banned from interacting with people on the internet. He couldn't go to websites where there's a likelihood that a minor would be speaking on there. So that includes not just Facebook, Twitter, YouTube, any website with a comment section, New York Times, the Washington Post, San Jose Mercury News, he can't go to the New York Times website, CNN.com, anywhere you can comment and potentially interact with a minor. He was banned from those websites. So he can't read newspapers anymore online. So he sued. He said that violated his free speech rights. And Anthony Kennedy, Justice Kennedy, wrote the majority opinion, and he said that in this day and age, access to the internet is the public square. The internet is the modern public square. So that phrase from the United States Supreme Court is what these plaintiffs in these lawsuits are latching onto and saying, well, if the Supreme Court of the United States says that the internet is the public square under the First Amendment of the U.S. Constitution, the California Constitution, which is broader, definitely encompasses the internet as being a public square. And in California, that means people can go wherever the heck they want in these public squares.
Well, if it was said in the Supreme Court that this is the public square, maybe that's why they're suing in federal court, because they're trying to latch onto that.
That's an idea. Yeah, they could be using that. But the U.S. Supreme Court's interpretation of the First Amendment, that applies in state court too. It spills over in state court. They also might be just suing in federal court because the defendant there, in that case, YouTube, they are a
Delaware corporation.
Yeah, Delaware company. So they figure it's going to get removed to federal court anyway, which is something Twitter could do too. They could transfer it to federal court.
And so your prediction is that both of these cases are going to lose, and not only lose, but lose big, because they're going to limit Pruneyard completely.
Yeah, well, I predict that the federal court case they'll lose. Dennis Prager will lose the federal case because the California Supreme Court has never applied Pruneyard to the internet. The logic is unassailable, but it's state law that they're trying to use, and no California court before has made that explicit finding that the logic of Pruneyard does apply to the internet. So the federal court is going to say, well, that's an issue of state law that hasn't been decided. So they'll probably say no, and then they'll lose. Or maybe they'll ask the California Supreme Court to weigh in on the question. But the federal law right now isn't going to allow that to happen. The state court case will lose. Jared Taylor versus Twitter, he'll lose that case. Not because he's wrong on the law, because he's right. He'll lose because the law will change, and the California Supreme Court will say, no, Pruneyard doesn't apply to the internet because that would destroy the business models of Facebook and YouTube. Or they'll completely overturn Pruneyard and say, we were wrong, it was wrongly decided, we reverse ourselves.
So what does Eugene the Volokh conspiracy think about it?
The Volokh conspiracy, so there's this law professor at UCLA, Eugene Volokh, and he's a great First Amendment expert, and I sent him emails about this and asked him to weigh in, and he has not. He didn't respond. So I don't know if it's if he's interested yet.
But maybe he'll watch this video and reply.
Yes, Professor Volokh, if you're watching, please tell us what you think.
Also, I feel like all the lawyers from these cases should actually talk to you, even though, we're sitting here doing this silly video. It seems like we're doing a silly video, but there's real knowledge in this noggin right here.
Yeah, so as soon as Packingham versus North Carolina came out, I looked at that and I said, oh my God, this applies to Pruneyard. This is exactly the logic of Pruneyard, but they're using it for the internet.
What's Packingham?
Packingham versus North Carolina is the one where the sex offender tried to post the comments. So when Anthony Kennedy came out,
and that was a majority opinion.
Yes, U.S. Supreme Court.
What year?
2017.
Oh, okay.
In the summer, it had just come out, and then the Governor Wilson's lawsuit representing Dennis Prager, that was filed just a couple months later. But in those couple months, I was telling all my lawyer friends, like, you wouldn't believe this. They're going to apply Pruneyard to the internet. This is how it's going to work. And then it happened. I'm a genius.
There you go. Yeah, no, I remember him saying that years before.
Yeah.
He was the first person to think of it.
Yeah, I even thought about that before. That's right. I preempted the California or U.S. Supreme Court.
So when it comes to Pruneyard or court cases, call Daniel.
I'm a freaking genius.
Yes. That's true. You can't say you're a genius. I'm supposed to say you're a genius, and then you just
all right. Well,
agree.
You're not telling them enough.
You're a freaking genius, Daniel.
Thank you, Brian. My name's Governor Watts. I'm a California free speech lawyer. Make sure you subscribe to my YouTube account because
he's a freaking genius.